All right. Today we're going to be talking about the access to justice gap. I am not shy or quiet about my opinion that the traditional legal model as we apply it today is broken. And what I mean by traditional model is, a substantial retainer up front, $3,500 to $5,000. There's usually a refill provision where if that gets down to 20%, they have to refill the retainer, which in the example of a $5,000 retainer is another $4,000 in short order. If we're looking to diagnose this problem, we're all lawyers. We believe in empirical evidence. We believe in facts. So let me point you to a couple of statistics that really blow my mind. Very quickly, whenever we're talking about access to justice, what do we mean? In this context, we're talking about people with matters that have been filed that have an attorney. What's the rate of people that have a matter going and actually have a lawyer? Now, I make that distinction because there's a whole other facet to access to justice that we're not talking about today. And that is people that need to file matters, people that have legitimate legal matters that need to be litigated, that simply don't file because they don't have access to an attorney. So it's not even a possibility for them to seek the relief that they need. So that's a whole other component of access to justice. There's probably 3 to 5 times the amount of people we're talking about today that need help just by that dynamic. But focusing right now on representation. How are we doing as an industry? Our job is to help the people that need help navigating the legal world. Well, back in the 1970s, we have statistics that show 99% of people that needed representation got it. Today, that number is 23%. If we're grading ourselves as an industry, we're failing. In the 70s, we had a 99%. We had an A+. We're at 23%. They send you to summer school for a 23% grade. That's how badly we're doing as an industry. And, when we look at our mandate to help people, what does that mean in the context of our profession? Again, it means we're failing at our number one charge, which is to help people. And, sometimes I get some pushback here. Firms say we're doing our best. We have some pro bono that we do. We help out at the legal clinic. That's fantastic. Those are the tools that are available to the most disadvantaged of us. That is a very noble direction for a firm, but it's not enough. And the truth is, if we don't solve this problem ourselves, the ability to solve it and the work will be taken away from us. It's already happening. In our industry, I encourage everyone here to go read the preamble to the Model Rules of Professional Ethics. We're going to post a link to that below. It's a very quick read, but I think you'll be a little bit taken aback about how much of that preamble is a mandate to our industry to evolve, to help people. Our job is to help the people that need us. The preamble tells us to step into the shoes of a private citizen that needs a lawyer. It tells us to actively change the legal industry, to challenge the bar for incidents of change, for places where there's room for us to improve the practice of law. There's one part of the preamble that always catches my eye because it is universally applicable to our duty to help our industry evolve, to help as many people as possible. Section 6 states, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. A lawyer should aid the profession in pursuing these objectives and should help the bar regulate itself in the public interest. So most attorneys interpret that language to mean, people that are of low income strata or can't afford our services, offer them pro bono, point them to legal aid. find some other way to get them help. I interpret that to mean anyone that can't access legal services should be given a vehicle to do so. The way our traditional billing model is structured, large retainers, followed by replenishment provisions that require large retainers. With this current model, we're preventing 75% or more of the population from accessing our services. By way of default, by the way we've done things for 150 years without evolving, we have essentially placed all of the middle class, people that have good income, we've placed them in the category that the preamble's referring to. People for economic or socioeconomic barriers can't access our services. And with a 23% representation rate, I would say our industry is only serving the most wealthy people in our society. That's not our role. That is not the purpose that our industry was designed to fill. The preamble of the model rules of professional conduct also support that. We're in a position where we're doing things for our self-interest as attorneys in our firm. Well, I have to protect my interests. I don't roll out of bed for less than $5,000. That's not considering where the client is coming from. In some states, instead of trying to appeal to attorneys directly like this to fix the problem in a for-profit manner and offer a different model, the ability to do so is just being taken away and given to someone else. There are sandbox states that are allowing paraprofessionals to do our jobs all the way up and through trial. I'm filming this in Arizona. In Arizona, you do not need to be a lawyer to file a family law case. Why is that? Because there were too many unrepresented people going through the system. And so if that's the growing trend for our industry, we're going to become an endangered species very quickly. The solution here is for us to adjust the way we bill our clients. And we're going to be talking about that a lot more in a lot more detail, but it's important to understand that we have a duty. We have a duty to help people. Attorneys always like to look to the rules. We're rule followers. We always look to a higher authority. What's the judge say? What's the arbitration board say? What's the regulatory committee say? Well, in this circumstance, what do the model rules of professional conduct say? They say we're failing. They say that our job is to be a public servant and that our duty is to our clients. Now, I understand we have families to feed. We have, employees that we need to pay. I can promise you the traditional model is not going to do that for you. Not in perpetuity, not in the long run. The traditional model is broken because of economics. And in the next video, I'm going to talk about that in great detail. But for now, it's just important to know we have a duty to our clients to meet them on their terms and find creative and unique ways to help them. And we need to do better. So I'm curious, how is your firm creatively meeting your responsibilities under the rules of professional conduct? Or are you? Please let us know in the comments below, and we'll see you in the next video.